the Glass Ceiling, and Government Careers panel. We have several exciting programs to come, including effective virtual settlement advocacy with our magistrate judges, and an in-person members appreciation event later this month. In a typical year, we host popular informal lunches with federal judges in their chambers, as well as a number of free events for our members, including a holiday party and our ethics program, offering many hours of free professional responsibility CLE. Nevertheless, in these highly atypical times, chapter membership has also provided a unique and excellent opportunity for people to engage in interesting legal programs and to network during a time of limited social contact. I encourage you to consider joining the FBA-Chicago Chapter. If you're interested, please see our website at www.federalbarchicago.org. And with that said, let me introduce today's panelists. Now in her second term at DePaul and 13th year as a law dean, Jennifer Rosado Perea has served as Dean of DePaul University College of Law since 2015. A nationally recognized leader in legal education, Dean Rosado Perea brings a wealth of experience to DePaul as an experienced administrator, a longtime advocate of student engagement and professionalism, and a respected legal scholar. One of only a small number of Latina law school deans in the nation, she has been recognized and honored for her commitment to diversity through her presentations on implicit bias, mentoring, and creation of innovative programs. Most recently, Dean Rosado Perea received the Aguila Award, the highest honor bestowed by the Hispanic Lawyers Association of Illinois. She also has presented nationally and regionally on the future and challenges of legal education before a variety of organizations, including the Association of American Law Schools and the American Bar Association. Dean Rosado Perea is an accomplished scholar and expert on family law, bioethics, and legal ethics, having published extensively on a variety of legal issues affecting children and families. Prior to joining DePaul, she served as Dean of the Northern Illinois University College of Law for 6 years. Franklin Valderrama is a judge on the United States District Court for the Northern District of Illinois. Prior to joining the District Court, Judge Valderrama served as a judge in the General Chancery Division of the Circuit Court of Cook County. While on the Circuit Court, Judge Valderrama also served on the Illinois Supreme Court Rules Committee and the Illinois Supreme Court Committee on Evidence. Judge Valderrama has served as an adjunct professor at UIC John Marshall Law School. Before joining the Circuit Court in 2007, Judge Valderrama was a partner at Sanchez, Daniels, and Hoffman, where he focused his practice on civil litigation. Judge Valderrama is a commissioner on the Illinois Supreme Court Commission on Professionalism. He also serves on the board of directors of the Illinois Latino Judges Association and is a member of the DePaul University College of Law's Dean Advisory Council, the Hispanic Lawyers Association of Illinois, the Cook County Bar Association, and the Illinois Judicial Council of Illinois. Judge Valderrama is a recipient of the National Bar Association's Thurgood Marshall Award and the Cook County Bar Association's Kenneth E. Wilson Award. Judge Valderrama was awarded the 2020 Outstanding Service to the Profession Award by the DePaul University College of Law. Enrique Aleman, Jr., PhD, is the Lillian Radford Professor of Education at Trinity University. He directs the Trinity Tomorrow's Leaders Program and co-directs the Center for Educational Leadership. While at the University of Utah, Dr. Aleman co-founded and co-directed a university community partnership for 10 years and served as Assistant Vice President for Student Equity and Diversity. He served as department chair and professor at the University of Texas at San Antonio for 5 years. Dr. Aleman's research agenda includes studying how race and racism impacts educational policy and shapes the experiences of Latina, Latino, Latinx, and Chicana, Chicano, Chicanx students and families. And finally, Anthony Garcia is senior counsel at the Boeing Company. Prior to joining Boeing in 2013, Anthony was with the U.S. Department of Justice. His last assignment was to the Gangs and Narcotics section of the U.S. Attorney's Office for the Northern District of Illinois. He served as the U.S. Department of Justice attaché assigned to the U.S. Embassy in Mexico City, Mexico, from 2009 to 2011. Anthony has worked in the Department of Justice's Office of International Affairs, where he worked international issues with various countries in Latin America, and the counter-espionage section, where he investigated and prosecuted violations of the espionage statutes, the Atomic Energy Act, and export statutes. Tony worked as an assistant state's attorney in the Cook County State's Attorney's Office from 1998 to 2003. In August 2019, he was appointed to the Illinois Gaming Board. He graduated from the University of Wyoming College of Law and received his undergraduate degree also from the University of Wyoming. And with that said, I'm going to turn it over to Tony, who's going to be moderating today's panel. Thanks.
Great, thank you, Sergio. So as Sergio said, the CLE is going to be about the Westminster versus Mendez case, which is a desegregation case, and April of this year is the 75th anniversary of the case. It's an interesting case. It predates Board versus Brown of Education. However, some of the actors that are litigants in the case and in the Westminster case also appear in the Brown versus Board of Education. Mendez was a key area in raising some new arguments in desegregation of public schools. And I hope you find that the information we provided for the CLE is interesting. This case, I think, oftentimes is overlooked by Brown versus Board of Education also, obviously, but is a really nice predecessor to learning the arguments that got us where we are. I'd like to start off with giving Professor Aleman an opportunity to kind of give us an overview of the case and some factual background.
Thanks, Tony, and thanks for inviting me to be part of this panel. It's an honor to be part of it. I'm sitting down here in San Antonio, Texas, and so it's what I do on a daily basis. I work with students, mainly teachers who are wanting to become administrators, and some of them who want to go into the professoriate, who study schooling conditions, study educational policy. And so it was good to be able to read the history of this. We don't often, as you mentioned, we overlook it even in education. It's not taught as much. And for me personally, being from South Texas, it was kind of good to get this kind of California history that's important for us to consider even today, sitting here in San Antonio in one of the most segregated cities in the country. So first, some of the things I think about is, segregation and inferior schooling conditions have always been part of the Mexican-American experience. And so that's part of what I kind of went into reading this and reading more about it. As you mentioned, tomorrow is the anniversary, the 75th anniversary of the court case, of the decision. And so for me, to understand that Mexican Americans have been fighting for equity via political action, via legislative action since the early 1900s. The first walkout or first boycott of a school by parents and students happened in 1910 in West Texas, a place called San Angelo, Texas. That walkout or boycott lasted for 5 years. Parents were protesting the inferior schooling conditions that their students were having to deal with. And so rather than send them back to that school that wasn't listening to them, they ended up sending them for 5 years, sending their students to Catholic schools or to the Mexican Presbyterian school that was located there in San Angelo. A former professor of mine, Dr. Richard Valencia at UT Austin, in his 2008 book called Chicano Students and the Courts, does a really good job, I think, of further historicizing and contextualizing not only the Mendez case, but all the other cases that were led by Mexican-American communities and families. He finds in his book that Mexican-American initiated desegregation lawsuits far exceed the number of cases in any of the other categories. So whether it's school finance, whether it's bilingual education, whether it's high-stakes testing, desegregation court cases were the most had the most number of cases that were being initiated by this community. He and other scholars also, have demonstrated how segregation spanned from cradle to the grave, with forced segregation in maternity wards, in swimming pools, in transportation, in schools, obviously, and even in cemeteries. Myself, I have personal history with that. My mother passed away several years ago, and she's literally buried in a so-called Mexican cemetery in South Texas. Even though the majority of the people in that cemetery are Mexican American, it's still referred to as the Mexican cemetery. So I think historicizing, how the schools and how lawyers and how activists have worked on these issues is really important as we try to understand the place of Mendez. Dr. Valencia in his book identifies 35 germane desegregation lawsuits, which started in 1925. The Laird versus Romo case from Arizona, and then was followed up by the Salvatierra case in Texas in 1930, and then finally by the Lemon Grove case in California in 1931. These three cases are kind of led up to the Mendez case. And so it's important also to understand that there's 35 of them that he's documented that really had an impact on the cases that have been called. So for Mendez, another thing that I kind of really was interested in is the fact that Gonzalo and Felicitas Mendez were really moving back to Orange County, which is where Gonzalo was from. They moved back in 1943. They moved back in the middle of World War II happening, and they were looking for a way to support their family. And so, they were into the agricultural business. They were able to finally lease some land in Westminster, which is where Gonzalo was from. And, they were basically leasing the land of a Japanese-American family. Japanese-American family had been, along with 120,000 or so other Japanese Americans, had been forcibly rounded up and interned in a U.S. camp. And so it was around the time of September 1944, they moved into town into 43. In 1944, when it was time for the Mendez kids to enroll in school, they approached the Westminster School District, and Gonzalo and Felicitas were told they had to attend the Mexican school in Hoover, which was very confusing to them at the time. They had other nieces and nephews that were attending the Westminster school, and so that raised a lot of questions. They found out that they had a French-sounding name. Their last name was Vidauri, so they didn't have a Spanish surname. Along with they were white-skinned. They were lighter-skinned students, as opposed to the Mendez kids who were dark-skinned. And so after some, frustrating, and kind of organizing that Mr. Mendez did, he organized a group of Mexican-American parents and challenged the segregation of their children, not only in Westminster, but in 3 other Orange County school districts. In 1945, Mendez and the other 4 fathers, which I think it's important for us to name them, William Guzman, Frank Palomino, Thomas Estrada, and Lorenzo Ramirez, they sued the school districts in federal court on behalf of their 15 collective children and the other 5,000 children that were at that time categorized as Mexican and Latin descent. The case raised for the first time the argument that segregating K-12 students based on their nationality or ethnic background violated the 14th Amendment to the U.S. Constitution. Unlike the cases that I mentioned previously that were cited in the Valencia book, it was the first school desegregation case in which plaintiffs argued that separate was not equal in K-12 public schools, because such segregation violated their rights under the Equal Protection Clause of the 14th Amendment. So I think this argument is, and this part of the case is what makes Mendez distinct from the other cases that are cited in the Valencia book. I think it's also important to note that African-American leaders and the NAACP in particular had been filing cases such as these over higher education. So Mendez was not the first federal desegregation court case, but it was the first to utilize the 14th Amendment argument in K-12 education, which is very important. Scholars argue that the Mendez lawyer, David Marcus, who was from Los Angeles, both may have been inspired by the NAACP legal strategies that were being used previously, but he also may have contributed to their legal strategy moving forward after Mendez. So it can be said, and I would view it as an example of how Mexican-American and African-American struggles were intertwined and reinforcing throughout this time period. I would also like to note that the Attorney Marcus's strategy should be, looked at, and is also a strategy that other lawyers employed in subsequent cases. First, he questioned the state and federal legal basis of segregation. Second, he had Mexican-American community members who attended the local school speak to extreme examples of segregation. Third, he underscored via testimony the examples of transfer denials when students wanted to transfer. Fourth, he had students testify about segregated schools and how they made them feel. And finally, which I think, didn't realize this until after I read this, is that he used testimony of social scientists to make the arguments that he wanted to make. So it was really in February of 1946 that Judge McCormick handed down his decision, which led to the end of de jure segregation in California schools 16 months later. The defendants brought forth the appeal of Mendez on December 10th, 1946 to the Ninth Circuit of Appeals in San Francisco, and the appellate school districts filed a brief reasserting the arguments that the federal courts had no jurisdiction and that separate but equal is legal. 5 important influential organizations submitted 4 amicus briefs in support of the Mexican-American children in the Mendez case, which I think is very important too. The NAACP, the American Jewish Congress, the Attorney General of the State of California, and the American Civil Liberties Union, together with the National Lawyers Guild. Each of these briefs, they let out different various parts of the arguments, and it is, to me, is another example of the value of collaboration and interest convergence in the quest of social justice. And so I thought that was very noteworthy. And so it was really April 14th, 1947, 75 years ago tomorrow, in a unanimous 7-0 decision, that the Ninth Circuit Court of Appeals upheld the district court judge's decision, paved the way to remedy that called for an end to segregation in the defendant schools. And so that's kind of a brief overview that I had. And again, as somebody who attended public schools here in South Texas, and have multiple generations of family who've had to deal with segregation, and now work with educators and educational leaders who are still working on these issues in an urban setting here in San Antonio, I think it's extremely important that we note the highlights of this case and try to figure out ways to challenge the continuing inequities that exist in our schools.
Thank you, Enrique. It's funny you should mention about the segregational pools and other locations. My family's from southern Arizona, and I have uncles that talk about not being able to go to the pool in the town because it was an all-white pool. And one of my uncles was one of the first Mexican Americans to actually go into the pool and jump in and start swimming with everyone. So it's not that far ago that these segregation cases and the segregation of public locations are still occurring. But no, thank you for that background, Enrique. Judge, I'd like to spin to you, and given kind of the background that Professor Aleman provided, if you can make some comments regarding the evidence that the civil rights attorney David Marcus used in his argument in the Mendez case at the district court level and at the Ninth Circuit, if you can.
Good afternoon, and thank you for having me as part of this very esteemed panel. Professor Aleman did a very, very thorough and excellent job in summarizing what led up to the decision, as well as some of the trial strategy and evidence that was used by plaintiff's counsel David Marcus at the trial. And to follow up on what Professor Aleman said, one of the things that was unique, if not unusual, was the trial strategy that was used by David Marcus, in that he sought to use social science and did so by calling social science experts for the purposes of establishing the injurious effects of the discrimination on the Mexican-American children. Certainly, this was something that had not been done, at least successfully, prior to this time, and it kind of paved the way, so to speak, for the subsequent Brown use as well by the litigants in that case. So one of the things that he was able to do was to bring in evidence that how did this segregation make the children feel? And one of the things that the experts testified to was this feeling of inferiority that emanated from the children as a result of this state-sanctioned segregation. And that was somewhat revolutionary. He also, one of the things that had often been advanced by the state, at least in the case anyways, as for the rationale or justification for this two-tiered system or binary school system was, well, the Mexican-American children, they're not proficient in English. They need to be in their own school, so to speak, so that they can learn. And he was able to produce evidence that that was just not the case, and that they were staying in the school, segregated school, irrespective of their advancing proficiency in the English language, and they were still relegated to the segregated school irrespective of their advancement in proficiency. So that was also evidence that came out, and Judge McCormick alluded to both of those findings, in other words, evidence before him, as part of his decision in making the conclusion that this was violative of the 14th Amendment. And he certainly cited the injurious effect on the children, as well as swiping away the proffered justification for the continued segregation. I hope I answered your question.
Yeah, no, Judge, thank you very much. I appreciate you pointing out the social science that was used as evidence and how it supported the district court's position. Given that type of new way of using kind of new evidence to support the court, do you have any thoughts on extrapolating that type of evidence and arguing it onto the appellate court? We know now that the appellate court, the Ninth Circuit, used that evidence to support its decision, but just kind of cutting edge for bringing in social science to help support an argument of that manner and throwing up those type of witnesses. Any thoughts on how the court relied on it, or it would be used?
Well, I think the notion that, as a matter of first impression, that you were having social scientists testify regarding the effect, the detrimental effect of segregation, certainly is new. But I think what that went to was, this whole notion up to that time was separate but equal was okay. So that as long as the facilities are relatively equal in terms of their tangible physical structure, the textbooks, the curricula, resources, and so forth, it's fine because they're separate, but they're otherwise equal. And I think what this went to the notion was that no, that inherently is still a violation of the 14th Amendment, because it does violence to these children and their own self-esteem. And one of the other aspects of it was, education has always been known to be the basis, if you will, for the inculcation of civics and the American civics for children. And if you are, on the one hand, segregating children, you are really doing a disservice or not really promoting the idea that this is all one country and we are all one, but you're really reinforcing the notion that they're two separate citizens, if you will. So I think that was also part of the strategy that was used, and obviously was used very successfully both at the district court level and at the Ninth Circuit, that both courts found that it really wasn't just about the equalness, if you will, of the tangible aspects of the schools, but it went beyond that. And that was a precursor to Brown.
Thank you, Judge. I think that's an important part, that the segregation concept had a disparate effect upon the students, that although there's supposed to be an equal treatment, even the facilities and the education being equal had a disparate effect on the students themselves. Strange argument for saying we're going to be stronger, we're going to unify you by segregating you, which seems somewhat counterproductive. Dean, I'd like to turn to you and just kind of get your thoughts on, how did the Mendez case affect other school desegregation cases, and if you could just kind of touch on its effect on Brown versus Board of Education. I know both the judge and Professor Aleman have mentioned that, but if you could just kind of go into a little bit more about its effect.
Yeah, I'll try to pull things together and dig a little bit deeper, because it's not a straight path. It's kind of strands of different things. So I just want to kind of, as we move kind of from the district court to the Ninth Circuit and then moving towards Brown years later, I think it's important to kind of think about how the case was postured at the end in the Ninth Circuit, because the Ninth Circuit did not it did not say there was a frontal, did not take a frontal assault in the same way that the district court did. The Ninth Circuit was like, hold everybody's horses, let's find a narrow way to have the Mexican students be able to go to their schools, but not really, as one would, commentator said yesterday, or in one of the articles, be an activist judge and kind of reach more further than was necessary. So I think it's important, a couple of premises of the Ninth Circuit, and then I'll get into kind of the road to Brown. So bear with me for a couple minutes. First, that Mexicans were not identified as a different race. They were identified as white. And so for purposes of the litigation, it was discrimination among whites, not between different races, because the state law had actually not included segregation of Mexican children in the statute. The statute only applied to Indian children and children who were of Chinese, Japanese, and Mongolian parentage. So basically what the posture of the case was is that the school district had gone rogue against the state statute, and that was really the wrong that was trying to be remedied by the case. And so I think the Ninth Circuit tried to stay in its lane on that. And also I think what was important too is that the stipulation was, again, there was not litigation about whether Mexican Americans were a race or not. They were conceded or stipulated to be white. And also, to Judge Valderrama's point, there was a stipulation as that the facilities, the tax, et cetera, were not unequal. So they really had to kind of face the unequalness in terms of the, as you say, the kind of the feelings and the experiences of those students. And they said among the white students, the Mexican students can't be treated differently. So we're going to kind of go on that track and really try to take a very narrow view based on precedent and not really try to take on Plessy. But then there were a couple of actors, the NAACP and Justice Warren. I want to take, those were really the two actors organizationally and personally and professionally that that paved the road to Brown. So first, the NAACP wrote an amicus brief, and as was mentioned before, most of the challenges of the litigation strategy of the NAACP was through higher education. They were moving incrementally through higher education spaces. They were arguing the segregation, separate is not equal, but they didn't want to go to the grade schools because they didn't think they could succeed there. So what Mendez gave them was the opportunity. Once the district court, the bold district court opinion was on, was out there based on psychological evidence, they said, here's an opportunity. And so some of you may or may not know this because much of the commentary talks about Thurgood Marshall authoring the briefs, but the first brief, at least, was drafted by Ronald Carter, who became a federal judge. Thurgood Marshall actually was ill, so Carter drafted the brief, and it was a powerful brief, and it took Plessy head on. It asked that it be overruled, it asked that it be distinguished, and it really talked about segregation of Blacks in the South as a model for the damage that could be done and would be done also to Mexican Americans in the Mendez case. And to reiterate some of the arguments that we've talked about that were straight on in the brief with the NAACP, that the segregation in schools deprived Blacks of their full potential, deprived states of the full value of the minority group's citizenship, that it imposed the cost of two systems on whites, so there was a harm to white students and their families as well. It promoted racial strife instead of tolerance, which led to othering, which is again a concept that we talk about now, which was really initiated in a brief like that, and really focusing on that notion of inferiority, that this sort of separate but equal evidence as a color cast attitude and feeling on the part of those who enforce it, that the group set apart has inferior characteristics which justify his separation from the majority. So again, taking all of that head on, and although there wasn't really a reference, I don't think, to the amicus briefs, as the professor said, there were a number of amicus briefs in that case, a coalition of them. And so the Brown case, though, in the amicus brief, towards Brown, it was a test case. Mendez was a test case on the road to Brown. And in fact, Carter talks about it basically being a model. It was almost identical, the brief that they filed in the Mendez case and the brief that they filed in the Brown case some years later. But I think it's important not to forget about the role of Earl Warren here, and how he helped move this along. So the NAACP was moving along its strategy. Mendez jump-started that strategy to take on Brown a few years later. But Earl Warren was the governor at the time that Mendez was decided, and he actually urged his attorney general to go in and file an amicus challenging the statute, and actually the statute itself, to strike down those the segregated categories that I just mentioned to you. He also then, when the case came down and it was on much narrower grounds, he himself made sure that the statute was eradicated, and that segregation, at least on its face, no longer existed. And then he became a Supreme Court justice, and not accidentally, I don't think, he was the author of Hernandez as well as of Brown. And even though there's no mention of the Mendez case in the Brown decision, commentators say there is no way that Warren could not have known what he was writing about, what the Mendez case was about, because there were too many similarities. There was a similarities about assimilation and education as being essential to good citizenship. There was a similarity that segregation limits the development of African American children, that segregation creates a sense of inferiority, and that segregation is inherently unequal, which was almost identical to what the NAACP had argued and what the district court in McCormick had actually stated back then in Mendez. So it really, it's a little bit of a circuitous route, but I do think that the NAACP and Earl Warren had a lot to do with how Brown was decided.
Thank you very much. I think there's a couple of points I want to follow up with you on and just kind of get your thoughts on. Do you have any thoughts on why the Brown decision doesn't cite Mendez or doesn't make any reference to Mendez?
Well, I think there are a couple of reasons that commentators have said. One is that Mendez was not a race-based decision. So it was not an equal protection based on race. Like I said, it was between whites, and so that would not have helped the advocacy or the foundation of the Brown decision. I think also some commentators have talked about that really, civil rights at that time was predominantly black-white. That the black-white binary was that in civil rights was identified as African American civil rights, and so it didn't seem relevant for Mendez to be cited. And also, the Ninth Circuit case wasn't so helpful, right? It was very narrow. It would have been citing a district court case that was really out of the mainstream, which again, as a matter of practice, probably the Supreme Court doesn't do all that much. So I think implicitly it kind of channeled the spirit of Mendez without citing it directly.
Why do you think the Ninth Circuit decided to rule or to make its ruling so narrow and keep it instead of broadening its decision? I mean, the court had the opportunity there to broaden its decision and chose not to. And I think that is one of the keys of the Ninth Circuit's decision. Any thoughts on why they kept it?
I'm guessing that Judge Valderrama has a better sense in terms of judicial role. I think that that usually my understanding of the judicial role is you try to decide on the narrowest means possible to get the relief that the litigants want. And so I don't think the Ninth Circuit was ready to take on Plessy, which was what the NAACP was asking them to do, and what the district court essentially did. And so again, I can't get into their heads, but I know that judges generally do like to try to find the narrowest way to provide relief to the litigants.
I think the dean is exactly right, Tony, and certainly courts of appeal, if not district courts, employ the methodology that the dean just said, which is when there's a constitutional challenge, you certainly try to find the narrowest path in addressing that challenge, as opposed to sweeping wide pronouncements. And to tie it back to something that the dean said, I think that the Ninth Circuit was able to look at the California school districts, and I think the dean used the right phraseology, that they had just gone rogue on their own in violation to the Constitution of California. So the Constitution did not require the type of discrimination that was being employed by the school districts. Now, counter that with Brown, where some of those school districts specifically by constitution, by state constitution, did require the segregation of the races. So you had those two distinctions, but that wasn't the case in Westminster, in Mendez. So you had that issue of the school districts doing what the dean just said, which is essentially, based upon the stipulation, discriminating amongst members of the same race. And I think that stipulation, to me, is such a defining part of Mendez, because it really allowed, I think, the attorney to try to secure a victory on behalf of his clients in a way that he thought would be one that the court could go with without having to deal with Plessy head on. And looking at it as an advocate, as he must, he's interested in how do I get this result from my clients, and not necessarily beyond that, but for my clients, what can I do? And I think that was, this stipulation is right at the heart of the Mendez case.
I think that's an interesting view on the Mendez case versus Brown versus Board of Education. Just some thoughts on whether you thought on the attorney representing Mendez and the litigants, whether he was looking at more focused on his client or more something, a sweeping larger change within desegregation in public schools. Was he looking at something at the bigger picture? I mean, obviously Brown versus Board of Education, that is what they were trying to do. But what are your thoughts on the attorney that was representing Mendez?
Is that directed to me, Tony, or?
Either one, you or the dean or Professor Aleman.
If the professor wants to jump in, I don't want to be taking up all the time, and the professor was very eloquent earlier, so I can defer for the moment. If not, I can jump in.
No, go ahead, Judge. Go ahead, Judge.
So, as the dean said, I cannot get into the mind of Mr. Marcus, but it would appear to me that he was able to look at the statute or the Constitution and see what it is that these school districts had done. And he was able to craft an argument that was going to say that what you're doing is not authorized and not even required by your Constitution. And that provides and gives a court almost a relatively straight path to be able to look at a document, the governing document, and say, does this document authorize or require the act of which you are being accused of doing? And if the answer is no, in fact, it's counter to what the Constitution requires, it makes it much more straightforward, I think, as an attorney to make that argument and hopefully be successful with that argument, because you're not asking the court to then really go out of bounds or step out too far on a ledge, because all you're really saying is the Constitution doesn't require it, doesn't even allow for it, and yet the school board or school boards are doing it. And therefore, you should find that that is a violation of the 14th Amendment. So that's my thought on it.
Mm-hmm. Yeah, and from what I've read, and obviously not everything out there, is Marcus seemed like he had brought some cases earlier on public accommodations relating to Mexican Americans. He didn't seem like somebody with a long-term agenda. He wasn't necessarily affiliated with any national organization or anything like that. And he took, I think, close to 3 years working on this case with those families, trying to get those families the relief that they wanted. And there's a great, in the documentary, there's a great, vision that that actually Mr. Mendez would ride around in the truck with him to try to make, to try to get buy-in from families while Mrs. Mendez was running the farm at the time. So it seemed to me he was trying to be a champion, but more of a local champion, if that makes sense, than somebody with a national, agenda like the NAACP or the National Lawyers Guild might have had.
Yeah, when I look at Marcus, my perspective is that was 1946, right? 1945, 46, 47. I also consider like there were groups like the American GI Forum, LULAC, that were really trying to kind of argue that they were American first and foremost. And so this was a time period that schools were really kind of instituting these Americanization programs. And so, how do we how can you segregate when you're trying to like take a real integrationist, a real kind of assimilationist perspective? And so I think he was just using that argument that you were mentioning earlier. The other thing too that makes what people are talking about that makes me think about is how, you know, certain parts of our history, Mexican Americans in particular, as that's how I identify, how sometimes the law considers us white and other times we're Mexican. And that my own family, right, if you go back and look at our own birth certificates and census records, whether you're my great-grandfather, grandfather, my father, myself, at different points in time, how we're considered white, and other points in time we're Mexican, even though we're not Mexican, we're like US citizens. So I think, you know, for educators, for those who are trying to implement policy, especially at a local level, like the Westminster school officials, they were considering the Mendez kids as non-white. I mean, that's what their policy was, and it benefited the white majority there, the white power structure, and they were willing to kind of identify the dark-skinned Mendez kids in that way. And so that's the other kind of the tensions amongst our own community in how I identify, and we still do it today. You know, in my introduction, whether you're Latino or Latina or Latinx, Chicana, Chicano, Chicanx, Puerto Rican. I mean, I think we struggle still as a community in self-identifying ourselves and claiming our identities and our unique histories. Although there's a lot of similarities across Latino communities, that's part of what, you know, that educators and people who implement educational policy continue to struggle with.
Dean, you mentioned the documentary for the Mendez case. Does that, and admittedly, I haven't seen the documentary. I've heard it's very good, but does that documentary, does it go into any, or give any insight into the case and the strategy, or is it more of something historical? Dean, I think
It is something historical. I think it's really from the voices of the children themselves, the Mendez children. And I think it was really interesting because, you know, Sylvia Mendez, who got, I think she received a Medal of Honor from President Obama for, you know, going to school and persevering. There was the youngest sister who didn't know anything about the litigation until she went to college. She was much younger. And then there was, I mean, I think what was for me kind of the most impactful part of the documentary as they told the stories, and it included the stories of the interned family who did their, you know, who leased to a Mexican American family without prejudice because they knew they would take good care of their land, which then brought them into the civil rights, you know, the civil rights lawsuit and making history, and then maybe national history. But Jerome Mendez, who was one of the children, he, you know, he went to the white school eventually. He said it was very difficult at first, but he said kids forget quick. He said he ended up getting along with all the kids. He ended up having sleepovers with the white kids. The white kids would come to his house. And so he said from his perspective, the litigation, it all worked out fine because we as children could live without prejudice and be able to be united and move forward. And so that was kind of his aspiration. So when I think about, did the litigation accomplish what it was designed to accomplish? The answer is yes, right? Because all those children got to go to school and get those experiences that they would not have otherwise had. So it's a very, you know, I recommend it because it's just an insider's view of the family and their experiences with the litigation.
Did you find the documentary on YouTube? Is that where you were able to see it?
Mm-hmm. Yeah.
Great. I think that brings us to a nice way to have Professor Aleman discuss kind of the effects, the social impacts and effects of the decision from Mendez. You can make some comments about that.
Sure. I mean, I think some of them were already touched on earlier as far as the effects. I did want to, like, as a way to contextualize it even further, about 10 years after that, going back to what the dean was just saying, I found out in the early 2000s that my mother was part of a desegregation court case, the Hernandez versus Driscoll case of 1957. And I never knew that growing up. I found out after she passed away that she was a student who testified in federal court, who testified in English because the district was saying that she couldn't speak English, and that's the reason that they were segregating them and retaining them for 3 years in the first grade. So to me, I think, you know, the effects of not only this case, but a lot of cases, I think it's really important obviously the work that lawyers do, but I think educators need to do a better job of bringing these kinds of stories and humanizing these cases in a way that can really impact what we're going through, as a society right now. And here in Texas, as in other states, there's these so-called anti-CRT bills, which are really aimed at minimizing the way we talk about race and racism in our history, the way we teach about the complexities of the law and policy and what that means for today. And I think young people are, whether it's back then or right now, young people know that these are the tensions that are in society, and they need to figure out ways to kind of work through them. It doesn't do us any good to kind of bury these or put them in a drawer and not talk about them. And so I think, to me, that's one of the effects of understanding these kinds of court cases. The other thing too, I think, is that there are scholars today, educational scholars, law scholars, Derek Bell's being one of them. He's passed away, but in 1980, he wrote a Harvard Law Review journal on the board, Brown versus Board, and interest convergence, known as the father of CRT. Talks about how he, as a civil rights attorney, might not have taken the same strategy that he did back in the day when he was fighting it that way, that there was other impacts of arguing for integration. Some of my colleagues, Dr. Gloria Latson-Billings from University of Wisconsin-Madison, Dr. Sonia Horsford from Teachers College, they've written about how the negative impacts that integration had on the Black school, on the Black community, once Black schools were closed, although they were low funded and they were not adequately resourced, you immediately got rid of the Black middle class. You fired teachers, you didn't have administrators, you didn't have the center of the community. So, there was a negative effect to ridding the Black community of a community space, of teachers who cared and loved their students, who had very high expectations of their students. And that right now in education, we fight for. The majority of our teachers are white. They don't always understand Black and brown communities. They don't always have high expectations of our Black and brown students. They're overrepresented in discipline. They're overrepresented in special ed. And so that's kind of a negative effect also that we need to talk about, that there weren't all positive effects with integration and with getting rid of, Black schools. And I think that's something that educators and educational scholars continue to struggle with today. And I think that's a direct result of understanding how Mendez came about and Brown versus Board.
For someone, that's an interesting comment that, well, there was a push to integrate the students into schools, that it seems that we forgot to integrate administrators and teachers into the school districts also. That's an interesting perspective.
And it's referred to, Dr. Horsford at Teachers College, she wrote a book called Learning in a Burning House. Like, why would you integrate into a burning house? Why would I drop my children off into a hostile environment where in my own community that was staffed with Black teachers and Black professionals that cared about the community and were culturally relevant and had high expectations? So I think the argument goes back to, why don't we just fund them at the same level? And Latson-Billings calls her, in her article in the North Carolina Law Review 2007, she asked the question, can we at least have Plessy? We're still segregated. Can we at least have Plessy? That's kind of the argument that's being had in the sense that we still have predominantly Black schools that are underfunded, that are severely underfunded. And so I think that's critical. Scholars continue to ask those questions.
Because we've all seen the footage from the 60s where students are walking into all white colleges, or minority students are walking in and being protected by the National Guard to get in, when in actuality they're going into an environment that isn't integrated, not only for the students but for the educational staff. But good point, Professor. The last question I'd like to pose to everyone is, obviously Brown versus Board of Education is very well known. I think most people learn that either in middle school or high school, and definitely during law school, and probably touches on depending on what kind of program you're on in college. Plessy is definitely touched on throughout the educational system in the United States, regardless of where you are. But Mendez, this was not a case that was taught in my law school, and I learned about it after I graduated. And at least based on my readings of the case and some literature I've read about the case and the litigants, seems to be a fairly important case. Any thoughts on why Mendez doesn't hold the same type of, isn't as represented as some of the other bigger cases at the Supreme Court, since this is one of the desegregation cases that helped get us to Brown? Any thoughts?
I mean, I think some of those reasons were already mentioned. Well, the first one that Valencia talks about actually is that the fight for desegregation for African Americans was a lot longer. So there's cases back to 1849. He mentions Roberts versus City of Boston case, and the first one being for Mexican Americans in 1925. So just the length in time and the fight, the challenges that have been in the African American community are longer. Second is what the dean mentioned. The law legally considered Mexican Americans white. And so I think that that's another reason, you know, the black-white binary, the black-white tensions, I think, for better or worse, or for, you know, if it's accurate or not, like they rise to the level of being more oppressive. Like I'm not into oppression politics. I think oppression is oppression, but I think that's definitely one of the reasons that it didn't rise to the level. And then lastly is, from my understanding, it didn't overturn Plessy. So, you know, the appellant districts didn't appeal Mendez to the Supreme Court. Maybe if it had, it would be different, but that's definitely maybe one of the reasons that it's not talked about as much.
If I may, maybe also there might have been, and I don't want to use the word tension, but we talked a little bit about some of the amicus that wrote in, including the NAACP. They were interested in trying to attack Plessy head on and using Mendez as that vehicle to attack Plessy head on. But that really wasn't something that, I mean, they filed the amicus, but that wasn't what Marcus wanted to do. And again, I go back to the stipulation because he was able to secure this victory by not having to have the district court, Judge McCormick, have to make that decision on Plessy. And certainly the Ninth Circuit absolutely didn't do that. So I think what you have is you have you have Plessy as a straight line to Brown, and Mendez gets kind of put off to the side because it wasn't really in the same track. But I think if you look at it from the point of view of social science and some of the evidence that was used, I think it would be more along the same lines or more along the same track. But for the reasons that we've already indicated, that's just not, I don't know, sexy enough to talk about it in a meaningful way to say, well, here's how, you know, Mendez was the precursor to Brown.
Yeah, my only footnote to I'd agree with all that is that I think con law, you know, is, you know, they've got limited coverage for everybody, and so they make these choices as we've been talking about. But I do think now, I mean, for law schools, there is a movement, and the ABA is behind it, is to have more racial justice and understanding in law schools about this beyond the, you know, the classic con law. So this case is in a case book on race and the law. Latinos in the law, and so more students are having to take those courses before they graduate. So I think there will be more law students and lawyers that are familiar with Mendez, even, you know, even if they don't get it in their classic con law course.
Great. Thank you very much. I'd like to open this up. It looks like we have some questions. I think Sergio's going to come back on to present some of the questions to the panelists.
Yes, we do. This one's directed to Professor Aleman. Could you repeat the names, please, of the scholars that are critical of Brown?
Sure. Sonia Douglas Horsford. It's her book titled "Learning in a Burning House" on Teachers College in 2011. And then Gloria Latson Billings in North Carolina Law Review 2007. Can we at least have Plessy? And then, of course, the classic Professor Derek Bell, Brown versus Board of Education and the Interest Convergence Dilemma, which is in Harvard Law Review in 1980. Those are three kind of scholars that kind of lead the field in really questioning the strategies that were taken by the NAACP and others in terms of arguing for integration and really looking at the negative effects it had on the Black community to close, you know, and to rid the Black professional class that were teachers.
Okay. And we have a question, perhaps also best addressed to you, Professor Aleman, but Dean, you may have some thoughts on this, or Judge. There's still a great deal of segregation in our public schools. Are you aware of any current efforts in the courts to address that?
Well, I can address it this way, which is not a great answer, but courts can only react to cases that are brought before the court. So to the extent that there are cases that are out there, that would be the way. In other words, they would have to be has to be litigation. Someone has to bring a lawsuit, so forth and so on. Certainly when I was in state court, I can definitely say that I did have the privilege to preside over a case that did somewhat challenge Chicago Board of Ed and their decision to close a particular school. And there were some allegations that the suggestion to close that school in a relatively diverse area in favor of a predominantly white area was born of some racial animus. So there are cases out there, but I guess what I'm trying to say is they have to be brought for the courts anyways to weigh in.
And I would add, I mean, it's also, the law has limits and litigation has limits, and it's a much harder to bring a case when it's just about impact than when you have discriminatory intent and it's evidenced. That doesn't happen quite as much anymore. But there are lots of ways that disparate impact and structural racism or national origin discrimination can take place. It's harder to prove though, and harder to bring. So I think maybe that's why I can't think of those cases. And I do think there are larger issues, and Chicano scholars talked about this even after Mendez. It really didn't do very much about language suppression, the segregation of neighborhoods, all of that. And those are kind of bigger, much bigger than just the educational system.
Okay. And let me just follow up on that with respect to Professor Aleman. I see with your work with Tomorrow's Leaders Program and the Center for Educational Leadership, is there a component in those programs where you address segregation or better put, desegregation and integration in education?
I mean, we talk about it definitely about building community, working across community. Here in San Antonio, we have 16 different school districts. We have a district that's 105,000 students, and we have one that's 2,500. And then part of it is the history of redlining, the history of segregation using school districts. And so that's very much a part, I think, of why, some of the Rodriguez versus San Antonio case came out of San Antonio for a reason. The school finance case that went all the way to the U.S. Supreme Court in '73. And I think that's something that we struggle with. All of our districts in San Antonio are all funded at different rates. You can walk into a high school in the north side, it looks completely different than it does on the south side, and students know that. So I think the way we address it is, how do you lead, how do you work as an educator in a same city that has very different facilities, very different access to resources, and how do you fight to change that? So a lot of the conversations are really still around funding and fighting at the state legislature and fighting through the state system.
Okay, well, we are right at the top of the hour, so I'd like to thank our panelists and moderator very much. It's been a fantastic program. Thanks to everyone who jumped in here to watch it. I will repeat the CLE code for everyone is 22134. And make sure that you've downloaded the handout materials along with the CLE forms. And that's it. Thank you very much, everyone.
Thank you.
Thank you.
Bye.
Bye.